And today we're going to look at how we can align innovation and regulation, so an ongoing challenge. I am Dr. Nicola Searle, a senior lecturer at Goldsmiths. And today we're going to look at an approach combining academic approaches and practice. So we're going to look particularly at how we can support innovation while doing so in a way that is responsible and balancing the interests of various stakeholders, including consumers, innovators, and society at large. We're particularly going to look at this in the digital area. So we're going to look at fast-moving emerging technologies, and one of the long-going challenges here is that innovation moves faster than regulation. So I'm delighted to introduce, we have two speakers today working at the nexus of academia and practice. We have Dan Hyde and Saverio Romeo, and we also have a fantastic discussant, Olivia Hamlin. I'll start off by introducing Professor Hyde. So Dan Hyde is professor at Queen Mary Law School and a cyber coach and business coach at the University of Cambridge Judge Law School. Dan is going to talk us through the development of cyber and tech law, and in particular, he'll look at examining the tensions between that innovation and regulation, which is the topic today. So he's going to set out the context and understanding, and I'll hand over to Dan.
Thank you, Nicola. Hello, everyone. I think by way of introduction, it might help to understand my role in the world of entrepreneurship I habit at the start. So I wear a number of hats, but the common denominator is entrepreneurship. So I trained and spent much of my career as a lawyer, and my initial approach to problem solving was through the prism of law and trying to ensure that anything done, whether in business or other part of life, was lawful. So I then studied and was later asked to teach and coach business, or more specifically entrepreneurship. And entrepreneurship, in my experience, generally involved tech, and that seemed to be because of the drive of most entrepreneurs I encountered, and they often wanted to achieve, change through disruptive or emerging tech. Essentially, that was tech that was new and able to solve old problems in novel ways. One of my favorite quotes is from Albert Einstein, because Einstein realized that if mankind was to survive, it had to learn how to solve old problems through new, different ways of thinking. And that's because the thinking that created an insoluble problem wouldn't provide the solution. And that fits really nicely with what I think entrepreneurs are trying to do and the disruption they are trying to bring to old ways of doing things. So I sit down with entrepreneurs or disruptors, and like a mechanic, I look under the bonnet of their startup project to try and understand all the moving parts. And I then have to try and work out the route that they are taking, what obstacles, whether commercial or legal, they're going to come up against. And that route is, if you like, the regulatory landscape. And I seek to understand, which laws, which regulations will apply, and what, if any, permissions they might need to be compliant. And this is where it starts to get tricky. To give you some context as to how the law drags behind innovation, even when keeping up is vital to society and law and order, let me use as an example the police and law enforcement. So this might sort of give you some idea as to why there's a gap between innovation and what's happening by way of progress and the law and how it treats the world. So in late 1984, two guys, Stephen Gold and Robert Schifrin, shoulder surfed a BT engineer. So for those of you who don't know what shoulder surfing is, it's a technique that basically means you stand behind somebody out of the way, so you can watch what their username or password is without them realizing. And they did that at a trade show, and they obtained his username, which was ridiculously 22222, and his password, which was more ridiculously 1234. And then they used that to access BT's Prestel computer network. And that caused much concern to GCHQ and MI6, because unbeknown to Stephen and Robert, the Prestel network that they'd accessed had been set up as a emergency communication tool and to launch nuclear strikes in the event of war. It also allowed them access to the establishment, and as they discovered, as they trawled the system, the message inbox of Prince Philip. So they were able to cause absolute chaos. And as I said, MI6 and GCHQ were climbing all over that because they couldn't allow that sort of behavior to be to continue or be encouraged. So the question was then, what were they going to do about it? So at this point in time, despite computers being mass produced and affordable to many since the 1970s, there was still no computer specific legislation in force that addressed this situation. And because there was no specific or apposite offence available, the two were charged under Section 1 of the Forgery and Counterfeiting Act in 1981. So they were essentially accused of creating a false instrument when they inputted the username and the password and caused BT to process that information and granting access. So rather like, if you like, forging a document. So quite remarkably, they were tried and convicted at Southwark Crown Court. They appealed and were acquitted, but the prosecution was so keen to try and push this home that they appealed to the House of Lords. And in 1988, the House of Lords finally looked at this, upheld the acquittal, and made it devastatingly clear that there was a huge gap in the legislation. And what they said was that this procrustean, that's a great word, attempt to force these facts into the language of an act not designed to fit had produced grave difficulties for both the judge and the jury. They said that the appellant's conduct amounted in essence to dishonestly obtaining access to the system, and that they did that by a trick. That is not a criminal offence, they said, and if it's thought desirable to make it a criminal offence, then it's a matter for the legislature rather than the courts. So there was clearly a gap in the legislation in its ability to deal with these sorts of offences. And the result of that was the Computer Misuse Act 1990, which attempted to plug the gap. Predictably, it sought to address this gold chiffering type scenario. But even then, it wasn't fit for purpose because it fell short, as it could only be used where the UK had natural domestic jurisdiction. It rapidly became clear that with the advent of the internet, online crime was borderless and international, could be committed remotely at pace and across jurisdictions. And computers had already progressed from being, large, unaffordable machines to portable, affordable, universally available devices. So these devices, for example, phones were in virtually every business and home and were carried by virtually every person, whether an adult or child. And mobile phones with computing power that would have staggered 1970s scientists meant that now virtually everyone everywhere was equipped to commit cybercrime. So, what was needed were laws that extend beyond national boundaries and had the means to apply overseas and, enforce those laws against cyber criminals. That need was finally addressed in 2015, so some 25 years after the Act was first passed, when the Serious Crime Act 2015 amended the territorial scope so that we could apply those offences beyond our national borders. And that was possible where we could show a significant link to the UK existed. Another change that came in 2015 was finally the addition of a new section called Section 3ZA, which created for the first time an offence of cyber terrorism. And that followed the belated realisation that war and terrorism were being waged by cyber attacks, and that where human welfare or national security was at stake, there needed to be the possibility of life imprisonment. So the lesson that emerges is that the law was and is slow to adapt, and that changes from innovation will take a long time to filter through to changes in the law. And that's similar the case when one looks to launch a pioneering business. The model of regulation for business is based on what we call a traditional business model. And the regulators, so chiefly the Financial Conduct Authority, try to apply rules and laws that, rather like the Forgery Act for gold and chiffering, were not designed to fit. Indeed, the problem goes even deeper than that, because entrepreneurs often tend to think that if what they are creating isn't specifically regulated, then they're free to do as they wish and that they're outside the regulatory perimeter. A classic example of that is where, for example, the venture applies blockchain, or let's say an NFT as part of its model, and the entrepreneur insists that neither is expressly regulated, so they're free to go ahead. The approach is flawed because one needs to look not just at the blockchain, the NFT, or the disruptive tech piece, but everything that's wrapped around the business before deciding if any regulations are engaged. So there are myriad use cases, for example, for NFTs. They're essentially computers, they are chameleonic, they have different applications across different industries. And what I, as a lawyer, have to try and understand is, what's the role of this NFT or this disruptive tech within the context of this particular business? What function is it performing? So, context is crucial here. If, for example, an NFT is operating like a stock, a share, an option, a future, or another financial instrument, then there's every chance that the project will need authorization. And that's because the regulators will say, okay, these rules are meant to apply for financial instruments, so they apply. And NFTs are just, one example. The same principle applies where the tech is effectively ahead of the legislative curve and where the regulation for that doesn't yet really exist. So in my role, I have to view the Financial Conduct Authority rather like the prosecution, for example, in gold and chiffering, and try and forecast what attempts they might make to force this tech, this business model into the language of regulations that were never designed to fit them. To be fair to the regulator and to the government, disruptive tech is really not easy to legislate. The varied use cases, the chameleonic nature of, for example, applied blockchain, which is sector agnostic, means that any regulation needs to address that particular application. And another complicating factor is the international reach of many tech businesses. It always amazes me when I speak to an entrepreneur and they assume that because they live in the UK or have incorporated their company here, that means only UK laws are engaged. The global nature of the internet and communication systems and the ease with which apps can be distributed through mobile devices means that many tech startups are targeting audiences across the globe, across multiple jurisdictions. And the result is that they need to map and appreciate exactly which jurisdictions they're engaging with and whether they're at risk as a result. So one example, which is actually a real life example that I've dealt with recently, was where I was asked to advise a gaming startup. Now, gaming startups can incorporate features that fall to be classified as gambling. So all that's needed for gambling to take place is an element of chance, or if you like, the combination of skill and chance in return for a prize. Now, in the UK and in many jurisdictions, that would then require a license. But if, as in this case, the business reach engages Dubai, it's much more tricky because you're then looking at a criminal offence because gambling is contrary to Islamic law. And you have a situation where not just the business, but the business owners themselves are in peril. So that's an example of, to say, how when you are looking to map what you're doing, you have to understand all the different regulations in all the different territories. And the problem here is that there isn't as yet any global, unified, homogenous approach to regulation. And this means that each jurisdiction needs to examine, and alignment between jurisdictions can't be assumed. If one looks at the current legal treatment of business data or crypto assets or distributed ledger or other disruptive technology around the world, it becomes clear that there are divergent philosophies and fundamentally different approaches to regulation that become difficult, if not impossible, to reconcile. And my expectation is that, unfortunately, this trend of divergence will continue. If one looks, for example, at the General Data Protection Regulations, or the GDPR, which came into force in 2018, there's a precedent there that doesn't bode well for a joined-up approach. The GDPR was the first attempt at a unified law to govern the collection and processing of personal data within a business context. And those regulations were rolled out and implemented across all EU member states, and the hope was that they would be adopted worldwide. But significantly, the GDPR emphasizes, the rights of an individual citizen and the sanctity of his or her data. And that runs root and branch through the GDPR from, the need to show an individual has given consent through to the embedded rights of that individual to ensure organizations can only keep the data for specified purposes. And that move, or the GDPR move, met with significant cyber and data initiatives in China, Russia, and the United States that were not aligned. I mean, indeed, in particular in the cases of China and Russia, rather than the individual being at the heart of the regulations, the role of the state was placed at the epicenter of their regulation and given most power over all the data. So that leads me to believe that the approach to regulating disruptive tech will, in all likelihood, be similarly fractured when we look at the global approach. So let's take a step back and look at how this all plays out for the entrepreneur trying to build a business. The initial stage of their startup was the ideation, the spark, the creation that set everything moving. Now, that idea needs to be commercially viable if it's to be commercially successful. And working through this, the question that must be answered in the affirmative is, is this achievable? Is it lawful? Is it permissible? The idea or its execution may need to change to ensure that it is. And that becomes an opaque calculation where there are uncertainties around the regulations and laws that apply. So thankfully, this won't deter many entrepreneurs who, in my experience, by their very nature, will push the envelope as to what is possible and will try to reduce the risk so far as they can. That risks will remain, some of them unforeseen or unforeseeable, is unfortunately unavoidable. And to quote T.S. Eliot, only those who will risk going too far can possibly find out how far they can go. And that neatly sums up the choice faced by many entrepreneurs in what is an uncertain, disruptive tech space. Thank you for listening.
Great. Thank you very much, Professor Hyde. And now I'd like to turn over to our next speaker. So Saverio Romeo is Associate Lecturer of Emerging Digital Technologies at the School of Management and Computer Science. He's also a consultant working on the same topic for a variety of clients. And Saverio is going to talk us through the challenges for consumers and industry in this area, and looking particularly at connected devices and the Internet of Things. He's going to look at the challenges between the code of practice and more formal regulations, and also, thankfully, touch on one of my favorite topics, cheese.
Thank you, Nicola. Thank you, everyone, for being here. So my background is in telecoms and computer science, and for 20 years and more, I've been working in the industry in a variety of roles. And in Birkbeck, I'll try to give some academic rigor to my work through some research that I'm doing in collaboration with other colleagues at Birkbeck. I'm teaching also on the subject. So what I'm going to really have the heart of the industry here today. If you go to next slide, I start from this, that is the academic only slide of this presentation, which in the industry we eat every day charts like that, which described the adoption or the dynamics of adoption of emerging technologies a long time. This is the technological cycle of Carlota Perez. It's interesting, not just the curve per se, because there are many, but the fact that Carlota Perez identified 3 macro factors, if you want, that drive together the interconnection of these factors, drive together the adoption and the dynamics of emerging digital technologies. And one of these is one she called institutional facilitators. And within that, there are basically rules and regulation. If we go to next slide, for the industry, what we look when we look at these things, and sometimes we make huge mistakes overlapping this stuff, and I beg pardon for Dan and Olive about that, but in the industry we see 3 main areas of common rules. One is the standards, the other one is the regulation, the other one is the policy. We do the standards as industry. There are standardization bodies, a pretty technological based type of common rules, if you want. The regulations are more about when the governments and the regulator enter into the equation on decide how things should be done. or how technological direction should be taken and so on. The policy has various aspects for us, as the aspect of a policy that's kind of imposed the regulation, if you want, but as also the effect of driving maybe technological development. What I'm going to do, if we go to next slide, I'm going to share two examples that I think reflects a bit the relationship between technology, emerging technology, and regulation from an industry point of view. And the first story is the story of the connected kettle. You know, behind the reason for having a connected kettle with your smartphone, during the early 2000, 2008, 2009, the first commercial products coming out, became that period an important aspect, a representation, if you want, of the so-called smart home domain, of all these connected devices that you have in a home environment. And the kettle kind of represented, particularly in the UK, represented a bit the smart home to a certain sense. There were a variety of products around at that period. Let's say that the first smart kettle is coming, early 90s. The pioneers of the IoT. One of the two devices they produced in 1989. One was a connected toaster, and the other one was the connected kettle. If we go to next slide, the problem from these devices is not just the kettle, was they were basically developed in a really terrible way from a security point of view. You go and see if you at the time. I'm sure that also today you can do that with some ethical hackers. Connected kettle in the marketplace from very famous players. 14, 15 seconds, you hack the kettle. And what does mean that you hack the kettle? What does mean that I'm hacking your Wi-Fi network? So I'm on your home devices, all of it. I'm on your smartphone. I'm basically in your life. I can do everything with your data. I can change everything. I can take everything. I can take credit card data and so on. So the connected kettle was the, if you want, entry point into your digital platform, your digital profile, your digital world. At the time, there was no regulation in place. No one was telling you to develop the connected kettle in a specific way. No one was telling you to introduce some security features or anything like that. It was completely open to your let's say to your desire. Introducing security features on a device has a cost, and many people decide not to do it. And we went on conferences in describing these things and discussing all of the same thing until, if we go to next slide, in 2018, after a longer discussion, I have to say, but in a sort of pioneering way, the UK came with a consumer IoT security code of practice, in which basically was saying, if you want to put in the marketplace a connected devices, which is primarily we are talking about consumer connected devices, you want to put in the marketplace, you need to follow certain steps. The device needs to have certain features in security terms, certain specifications. Otherwise, you can still do it, but it's not the real right connected IoT device, which can ensure security to the consumer and so on. And you can go and read this code of practice. It's done in a very nice way, very brief, 16 pages for 16 points, describing in a very nice way on how to develop a connected kettle that is safe, relatively safe. You never have 100% security on a device, but which is not really like the previous one, in which I go in 14 seconds and I see the password of the connected kettle is 1, 2, 3, 4, 5, 6, 7, 8, as Dan said. So at the meantime, anyway, is that the smart devices, the connected devices in a home environment have evolved massively. It's not just the ability now to connect to the kettle and remotely say to the kettle, just switch on or switch off. At the moment in a smart home environment, in a smart home domain, I have a number of devices that are using artificial intelligence and machine learning features, which can do a number of things in the house. So once the regulation, the code of practice, if you go to the next slide, remember it's the code of practice, it's not a regulation. And is a type, if you want, a soft regulation, if you want. Olivier and Dan can define it better, but it's not something that enforce me to develop the connected kettle in a specific way. They just suggest me to do, look, these are the guidelines for developing a connected kettle that ensures security to the customer. And this is the same on all the smart home devices. Again, the kettle is an example because it's maybe a funny one, but the smart meter is the same. Energy smart meter is more or less the same. You have a thermostat. I can give you plenty of stories on thermostat that were unsafe and unregulated. There were stories like the smart baby monitor. So there are plenty of it. So the idea is that this example shows you a domain in the industry in which the technology moves also in a very imperfect way, but the regulation struggle to come. And when it comes in 2018, it is good, but the technology has gone further down the line. So today we have the Alexa, the assistant in the house, which has other implications. So this is the first story. The second story, if you go to the next slide. Now, I don't know if how your knowledge about the IoT. The IoT, the Internet of Things, basically, in a nutshell, is a collection of devices in a space that gathers data to understand the condition of the space and to change that condition. The example that likes to Nicola about the cheese, when I was in my dissertation was about creating a device for a cheese seller to measure certain indicators in the cheese seller and communicate these indicators to, at the time, not a smartphone, but a computer. Now I can create this device. I put this device in the cheese cellar in Italy. I measure certain indicator. I gather. Then I send through a SIM. I can put a SIM that you have in your phone on this cheese. My granddad because it was my granddad's cheese cellar. You put the SIM in it and you create this device. Now let's say I want to sell this device in the UK. If you go to next slide, if I have to sell this device in the UK, I cannot just bring the device and sell it. I need to change the communication setting and to change among many other things. And to change the communication settings, I need to find an agreement with a local mobile network operator. And this is I'm very simplifying. This issue is called IoT roaming, which is more or less like the mobile communication roaming you have when you move from the UK to another countries and vice versa. Has a lot of implication from a business perspective, introduce a lot of cost, a lot of management complications and so on. So the idea is, why don't we regulate, and going to Dan's point, why do we not harmonize among different countries the possibility of moving this device from one country to the other without me as a business, as a startup, every time go to different countries. First of all, I do not understand the regulation of that country. I do not know the mobile environment of that country. I spend a lot of money to talk with consultancy. At the end of the day, I'm not doing anything. There is another school of thought that says, the market will adjust that. The market will sort it out. Technology is evolving. Don't worry, you can use different type of connectivity. You don't need to go to an operator. We can use other type of connectivity. It's fine. Tech will do it. So we go into, if you go to the next slide, we go into this domain, this frame of mind that there is in the industry, in which on one side, yes, we have to regulate. And I have to say, yes, we have to regulate, and it is very annoying that you have to regulate because complying to the regulation means cost for me. Therefore, that is the opposite. Let's not regulate, please. As an industry, we can do it. As a technology community, we can do it. We can go around, we develop our technology, and the regulator will never be able to stay with us. So these are the logic. Maybe the two extreme, and obviously there are places in the middle that can be discussed. And these are two very simple examples. But if you go into what Dan said, there is an enormous amount of discussion to do, starting, I don't know, data in the edge. This idea that today you send the data into the cloud because in the cloud you can do all your intelligence and analytics. Instead, what I'm going to do, I'm actually going to do on my kettle the intelligence So I'm transforming my kettle, not just in a connected one, an intelligent one that can analyze the data. What that means from a regulation point of view, do I need to be careful about what my kettle does? For example, Dan was mentioning about the blockchain. Blockchain is an enormous place for regulation. I mean, there is plenty of unregulated things. I mean, we can stay here for ages just talking about the unregulated environments there is in distributed ledger technology, and then on AI and so on. So these two situations in the industry are very relevant. On one side, let's say the delay of the regulators. On the other side, this debate, yes or no, for business reasons. So if we go to next slide, we are in a the CIMR paradox the other way around. Achilles we have a collection of Achilles running very fast, and I'm putting more Achilles because today we need to reflect in a converging way in technological terms. We cannot think to regulate blockchain and then we do not regulate artificial intelligence. We cannot think to regulate blockchain and not the IoT, and so on. So these are things that come together, and therefore we need to think about them together, not as an isolated piece of technology. Does not exist anymore. On the other side, then we have the government that moves slowly. That is the reality. They move slowly. I mean, I gave the example of the consumer IoT product, which is one of the fastest one, I have to say. But there are situations in which, we're 20, 25 years still debating what to do. The IoT roaming is a problem of a long time ago. It's not a new problem. So the question is, what to do to go back to the Zeno's paradox, to make the government an Achilles? Do we have to do that? Is it possible to do that? Do we need to change the decision-making system? There were at the time, linking to Dan, during let's say, the more exciting period of blockchain, this idea, there were a couple of academics to think about the use of distributed ledger technologies as a way of changing the decision-making system. And there was this idea of the distributed autonomous organization, which failed dramatically for a variety of reasons, but was an interesting reflection because it was basically criticizing the decision-making process in relation to technology policy. So these are big questions into the. I have to say, from an industry point of view, if you talk with the industry, yes, they want to transform towards in Achilles, but no, they don't really put the right attention to it because they are too focused in the development of the tech. And yeah, so the 2 point is this: the government comes, the regulator comes, but the technology is too fast, is extremely too fast, and the technology community is not always welcome to regulation. Therefore, it's important to understand what degree of regulation do we apply, and to what extent do we involve the industry community to regulate into the regulation debates. Many times, we regulate without involving them, and probably it's a mistake. And I think with that, I've finished. If you go to the next slide, yes, thank you.
Great. Well, thank you very much, Saverio, and apologies for the joke. I think you've left us hungry to hear more. So should we move on to our discussant? So we have Olivia Hamlin, who is a lecturer in law at Berkeley.
You're muted, Olivia.
Sorry, thanks very much, Saverio. Thanks, Nicola, and thank you very much to Dan and Saverio for two extremely thought-provoking presentations. I'm going to use my role as discussant to draw out a couple of the many themes these presentations raised. As a legal academic with an interest in how we regulate emerging technologies, I'm hoping to contribute some insight into how we might think about the themes raised from that perspective, as well as do what academics like to do, which is to complicate things a little. I also aim to pose a couple of questions to our speakers to help prompt discussion, though I suspect discussion on these issues won't need much prompting. So the two themes I want to discuss are regulatory connection and regulatory approach. First, regulatory connection. Now, the problem that the law often lags behind swiftly emerging and disruptive technologies was at the heart of the issues identified by our speakers. Roger Brownsword has characterised this challenge of ensuring the law keeps pace with technology as a matter of regulatory connection. This is a generic challenge likely to affect the regulation of most, if not all, new technologies, and it can help us think about why it's so difficult to ensure the law keeps up with socio-technical change. Dan's account of the initial jurisdictional limitations of the Computer Misuse Act and Severio's account of inadequate regulation to ensure the security of the connected kettle are both examples of regulation being or becoming disconnected from the technology in question. Thinking briefly about the regulator rather than the entrepreneur, the question is, how do we keep the regulation connected to the technology? There are various methods, and we might take Dan's account of the Serious Crime Act extending the Computer Misuse Act to catch crime committed outside the UK as an example of using legislation to re-establish regulatory connection. So I want to focus on three types of regulatory disconnection identified by Brownsword. They're not necessarily distinct categories, and they may blur and overlap. Firstly, he identifies descriptive disconnection. This occurs when the covering descriptions employed by the regulation no longer correspond to the technology or to the various technology-related practices that are the intended targets for the regulation. So here the mismatch between regulation and technology concerns a lack of descriptive fit. For example, where the definitions which trigger application of a law don't capture the new technology. And we could argue that the gold chiffrine example, where their actions escape the parameters of existing offences, broadly represents this type of disconnection. Secondly, normative disconnection. This occurs when the technology and its applications raise doubts as to the value compact that underlies the regulatory scheme. For example, because a known technology is now being applied for a different and questionable purpose, or because a new technology raises questions of principle or policy that are not clearly settled by the regulatory regime. Here, the mismatch between regulation and technology concerns a lack of moral fit. And I wonder if this type of regulatory disconnection is at play in Dan's example of needing to consider the function a particular NFT is performing in order to advise on compliance in a landscape where the operation of these novel instruments may start to strain against the function or behaviour of instruments envisaged in the relevant regulation. Finally, disconnection can occur where there's a mismatch between the assumptions about the business model on which a regulation is based and how the relevant business model operates in practice. If a regulation embeds a specific business model, developments in who carries out a particular behaviour targeted by the regulation may hasten that regulation's obsolescence. So Dan, I was very interested that you mentioned attempts by regulators to force not only technologies, but also business models into regulatory frameworks designed for different purposes, presumably in an effort to maintain regulatory connection. And I wonder how much you encounter this type of practice on the part of regulators. And more broadly, does it make sense from a practitioner's point of view to distinguish between different types of disconnection, or is the reality much more messy? Now, I want to complicate things a little and argue that although regulatory disconnection is a significant challenge, it's not a simple matter of the law either keeping pace with technological innovation or not. Technologies rarely emerge into a regulatory vacuum. The lack of any offence applicable to Golden Chiffrine's actions is perhaps an example of such a vacuum, but I would argue there are more, or at least plenty of experiences which suggest the opposite. For example, Dan cited the existence of the FCA and authorisation procedures potentially applicable to blockchain and NFTs. To add an example from my own field, emerging nanotechnologies are at least partially covered by existing regulations concerning, amongst other things, chemicals and cosmetics. Indeed, in 2006, it was estimated that up to 60 major pieces of EU legislation across a range of policy areas applied to nanotechnologies. So in this situation, the problem isn't that there's an unregulated Wild West, it's that the regulatory landscape is extremely complex and fragmented, full of gaps and overlaps, all of which is exacerbated when the global multi-jurisdictional dimension is considered, as Dan also mentions. And this presents an additional set of problems and uncertainty to entrepreneurs and regulators. And I believe Dan touches on this complexity when he discusses the need to discern the relevant laws, regulations, and permissions, and to anticipate the likely approach of the relevant regulators. So Dan, I'm wondering, to what extent do you encounter situations in which there's no law, and to what extent are you confronted with this type of pre-existing fragmented and complex regulatory landscape which you have to pass for your clients? And I realized that we didn't discuss this before we so I was just going to go through my comments and let you answer at the end, but if you want to answer now, then I'd leave that open. I don't know, Nicola, if you have any thoughts about when we do questions.
I was going to open it to allow Dan to respond and then open it up to wider questions. So if you wanted to finish and then.
Okay, so I'll
yes,
all the
please,
questions together. Right, okay, I'll get to the end of my comments then. Thank you. So secondly, I want to think about regulatory approach. So in other words, what do we mean when we talk about regulation? Now, traditionally, regulation is regarded as hard, i.e. strict rules or requirements backed up by sanctions. And there's a sense, at least in my field, this is how regulation is regarded by industry, often accompanied by negative connotations of inflexibility, a one-size-fits-all approach, and centralized control, some of which may at least sometimes be true. It's been persuasively argued by people like Gary Marchant and Kenneth Abbott that a more effective approach to governing emerging technologies is to employ a combination of hard regulation and softer instruments, such as guidelines, voluntary reporting mechanisms, and codes of conduct. For example, the Code of Practice for Consumer IoT Security, which Saverio cited. Soft law offers many advantages. It's flexible, it can respond more quickly to emerging technologies, it can clarify what exactly is being regulated, it can supplement existing regulation by, for example, setting out guidelines for compliance. It allows for collective learning and experimentation amongst industry and regulators, and it can be hardened into law once we're clearer about the issues and appropriate regulatory responses. There are, however, limitations, the most significant of which, as Saverio points out, is that codes of practice and other forms of soft law are not hard regulations, i.e. they're not enforceable, and this can lead to low rates of compliance and participation amongst industry. And soft law instruments can still take a long time to develop, as the IoT Code of Practice demonstrates. In addition, the flip side of flexibility is uncertainty, and indeed Ellen Stokes has argued that industry may in fact sometimes prefer hard regulation as a source of certainty, stability, and clarity. As Saverio highlights, there are debates between those who believe regulation is necessary and those who don't, and who instead look to the market. I'm not going to go into the arguments for and against regulation, except to note that relying on the market isn't necessarily deregulatory, and that's simply because markets need huge amounts of law, regulation, and regulatory resources in order to function, not least to provide for the creation and enforcement of private rights. However, in between those pro and anti-regulatory positions, there's discussion to be had regarding the combination or sequence of instruments we employ to govern disruptive technologies. In other words, our regulatory approach. This could even involve, at least for a time, doing nothing except perhaps monitoring the situation or commissioning further research. The reason I say in between those positions is because I'm curious to know from Saverio and Dan, based on their interaction with entrepreneurs, whether entrepreneurs tend to reject, resent, or accept the need for regulation, and whether you've encountered any preferences for particular types of regulatory approach. So are entrepreneurs more amenable to regulation in the form of softer instruments, or do they gain some comfort from the greater certainty of hard regulation? Or are they pragmatic and they just want to be told their rights and obligations so that they can get on with developing their innovation and business? And I suspect it's impossible to generalise, but I'd be curious to hear more about both of your experiences working with entrepreneurs. Okay, I've got a couple of other questions, but I'm not going to abuse my position now. So I'm going to hand back to Nicola and perhaps ask them later on if there's time. Thank you.
Thank you, Olivia, and that's exactly what I'd like to do. So I'd like to give Dan and Saverio time to respond, but we also have existing questions in the chat, and I'm sure the audience has some more. So time permitting, Olivia, we'll come back to you. Dan and Saverio, if you could pick up on a couple, but not all of those comments, and I'll leave it. I think I'll go to Dan first.
Okay, so if I could take the last question first, actually, because it's freshest in my mind, which is effectively, in my experience, what are entrepreneurs looking for? What are their preferences in terms of, hard regulation, soft regulation, or no regulation? I think the best way of describing their approach is nearly always they want the path of least resistance. So they'll have an idea, and they'll want that idea to fly. And the minute you start telling them, for example, that it either may not be possible, or that it may be possible, with strings attached in the forms of permissions, authorizations, or so on. So whether it's hard or soft, they will kind of tend to try and push back against that. But that makes sense, because look, I'm going to be really frank about it. If you're an entrepreneur and you've got an idea and you think it's going to, change the world or make you money, or both, the last thing you want to be told is that there's something kind of in your way, and also dealing with that obstacle, in dealing with people like me, is time and money. So normally the question I'm asked virtually every time is look, this is what we do. Is it outside regulation? And what they mean by that is, is there a way that we can execute on this idea safely? So, without having to get permissions from, say, the FCA, which can be time consuming and costly, or without the fear of, being prosecuted, or like, FTX, brought down at some point in the future. That tends to be the approach. And I have great sympathy with that, as I say, because they really just want to see a way through. The other thing I think everyone here in the audience ought to appreciate is, this is also highly relevant, don't forget that, when you're dealing with the regulator, there's a lot of fear. So a lot of entrepreneurs will say to me, if we suggest maybe trying to engage with them, hang on a minute, that's going to put us on the radar. So if we can try and use their sandbox and we can run things past them, but hey, what if we can't find a way through? We are on the radar. We've literally said to them, here we are. So it's not it's not straightforward. And the other thing, just before I finish the answer, is the global scenario is very important here, because the other thing I find, so especially, for example, so in Cambridge Judge, where we'll have lots of international students and cohorts that are from all over the world, they'll say to you, okay, if it's not possible in the UK, where is it possible? So for example, Dubai is quite a good example, where sometimes we can say to them, okay, in Dubai what you're doing is regulated, but it's regulated with certainty, and it's quite easy, to kind of plug you in and have you up and running in Dubai. So obviously that's great, because again, that's, if you like, the path of least resistance. There's some effort involved, but we can tell them quite precisely what's involved in terms of, their actions and costs to get going. That's not always the case in the UK or Europe, or certainly in the States. So I think that's the answer. I think they look for the quickest way through. And again, don't forget, there's cost can be critical here, because to most entrepreneurs, lawyers or business advisors or accountants, that's not sexy for them. What's sexy for them is achieving, executing, getting the thing up and running. They really don't want to be kind of pegged down. And also, it's, as I say, it's very expensive. So I think that's it, really. I think in an ideal world, most entrepreneurs, because as I said in my talk, they push the envelope, will sort of try and get outside regulation if they can. But if they can't, they want to see the most straightforward way of doing it.
Great, thank you, Dan. Okay, so Saverio, if you could pick up on a couple of points, and then we'll move to questions from the audience.
I think really the points I want to pick up is on what Dan was saying. and I completely agree with you, with him. And the only point I want to add, that there is an important element for support services in this area for startups. So they really need help, because they will never look at it. They will avoid it. They will avoid, there's a big beast in front of me, let me run away. So the support, the accelerator, everything is happening in this sort of environments for startups from a legal point of view is essential, because otherwise, sooner or later, their approach, their business, their technology will be somehow blocked by regulation that they did not know about it or did not want to know about it. So this is my on the previous two question from Olivia. There may be more downside. I mean, it's a bit more regulation low side. Thank you.
Great. Thank you, Saverio. And we have already one question in the chat. You can we have about 5 or 6 minutes to go through questions. So I can see that Daniele has put his hand up, and Andrew, you can either put your hand up or it will be asked by Ola. So I'll go to Daniele first.
Very interesting indeed. I mean, from what I learned is that basically we should adhere with the fact that the institutional process goes behind the innovation process. And that's, I mean, is a quite important lesson that we know from a variety of different fields, you know. And actually, this has the double effect that sometimes it may unnecessarily block some sorts of innovations. And that's, of course, there are quite a lot of differences across countries. Think about drugs. In some countries, the regulation process is faster, and some countries may benefit from new drugs much faster than countries in which the regulation process is much lower. But the other side is, of course, that you can get a regulation process which is too soft, and then you can get drugs which are not good, but even bad for your health, you know. Now, since you have been thinking about this issue, what do you think can be done in order to get the process of regulation at the same pace of innovation? Is it possible to think that parliaments, the legislative bodies of modern democracies, will somehow empower some groups of citizens which will quickly assess innovations and decide the sort of regulations needed?
Great. I'll let Saverio or Dan pick up on that. And if you could keep your answers short, that would be great.
Quickly, so one of my belief and my experience also with dealing with various governments on the, I mean, politicians, so not the civil servants, is that the level of technological understanding of the political class is not good enough to do any jump. And that is, you know, is something that with time, obviously, we can kind of fix. No, we cannot fix from one day to the other, but the political class does not really, it's not that I want them to understand what the technology is. I want to understand what the technology enables you to achieve and what type of resources that technology is needed and touches. So if you understand that, then maybe you can accelerate your thinking and accelerate in the decision-making process. But from my experience, are very few the politicians that have this understanding.
Great. Dan, I'll give you an opportunity to respond, and then we have 2 questions that hopefully we'll be able to get to.
I'll be very quick. So I was just going to basically second what Saverio said. I mean, I've had some experience. I was actually involved in being a special advisor to the Law Commission in terms of, so they were looking at the adequacy of laws around things like cyber. And it's not just that politicians don't have great technology. It's also that there are other drivers at play. So I remember telling them about gaps and saying, for example, we were talking about all the possible things you could do, you know, at speed now with cyber and communication tools. that really put the country at risk, and the inadequacies of laws, just dealing with all of that. And the problem they had was they were saying, yeah, but Dan, you're right, but we can't do anything about it because the public won't accept that. We can't kind of have cyber laws that are going to, rain down such serious penalties on people. So it's a problem because they're not just looking at matching, if you like, progress with legislation. They're also looking at the political position and their own, that what's in it for them, basically. I mean, a classic, really quickly, one of the things I was asked to talk to them about was cyber laws, and I pointed out that things like Official Secrets Act and spying, and I was giving them examples of how you could very easily pass on state secrets and other things, and there was a bit like golden chiffering, there was nothing really to deal with that adequately, and they accepted that and said they'd think about it, but would the public accept somebody getting life or basically being deemed a traitor or guilty of treason in a situation which was so technical, I think was what they called it, that people wouldn't get their heads around. So nothing ever changed. So they agreed with all my recommendations and said they'd put it under scrutiny, and I think the Official Secrets Act was never changed, so it's still lagging behind. And it's the same with many of these areas. I think, as I said, Saverio said, what they need to do is to bring in and give more influence to the people who are, to innovators, to people with technology, people who can actually explain the position to them, but actually then take that on board and not be, as I say, driven perhaps by other more, but basically by politics.
Great, thank you. I'm afraid we only have less than 2 minutes, so I don't think we'll have a chance to get to the other questions. There is a question in the chat, so Saverio or Dan, if you want to have a quick go at answering that in the chat, that would be great. So with that, I would like to say very much a thank you to our audience, to our organisers and our speakers. I don't think we managed to solve the issue of how you regulate and support innovation in emerging and fast-moving technologies, but I think we provided a lot of food for thought and look forward to ongoing conversations on this topic. So thank you very much.